Hello YouTube, welcome to the very first episode of Know Your Law, and on today's episode we'll be exploring the topic of consent in English law. We'll be looking just briefly at the meaning of the word consent, then we'll be looking at the criteria to test for valid consent, and lastly we'll be looking at consent in different contexts and as a defence to different types of harm. So let's get into it. So first of all, looking at the meaning of the word consent, we have a few sources to look at. The English dictionary definition is that consent is a voluntary agreement or acquiescence to what another person proposes or desires. The UK Law Commission from 1998 says that consent should be defined as a subsisting, free and genuine agreement to the act in question. And lastly, the current, most up-to-date and authoritative version is found in legislation. The Sexual Offences Act 2003, Section 74 says that a person consents by choice if they have the freedom and capacity to make that choice. It is this definition that we will now use, we will explore, and the one that the criteria for a valid consent is based upon. So let's move into that now. So for the second part of the video, we're going to be looking at the test for valid consent, and this is a three-part test. Firstly, the person must be free to give consent. Secondly, they must be informed of what they are consenting to. And lastly, they must have the capacity, both physical and mental, to be able to give consent. So let's look at these in a bit more detail. Part 1, where a person is free to give consent, this means that they must be free from any fear, coercion, deception or duress. Effectively, you cannot force or pressure a person into giving consent. The case we have here is Rvdiker, 1981. In this case, it was held that the absence of physical violence will not invalidate a consent, but fear can invalidate a consent. Effectively, if a person is being forced, but without the threat of physical violence, but maybe at the fear of possible violence being inflicted, then that will invalidate their consent. Part 2, we look at whether the person is being properly informed about what they are consenting to. And we have a few cases here to help us demonstrate the point. Clarence, first of all, from 1888. In this case, a wife who had consented sex with her husband was also held to impliedly consent to a sexually transmittable disease that the husband had, despite not knowing about it. Secondly, we have R.V. Williams, 1923. In this case, it was held that a choir master who had convinced a younger female member of his choir to have oral sex with him on the condition it would improve her breathing was guilty of rape because he was deceiving her as to the nature of the act. He had lied to her and she was not properly informed about what was going on. Next, we have Tabassum in 2000. In this case, a man posed as a medical practitioner in order to examine women's breasts. He had no medical license and therefore he was guilty of assault because he had deceived them as to the nature of the act and what he was doing. After this, we have quite an important case, Rvdiker, 2004. In this case, it was held that consent to sex does not amount to implied consent to a risk of infection. So this has the effect of overruling the previous case of Clarence, and also you must disclose the status of any infection you may have. Next, we have RVB from 2006. If a victim is willfully ignorant of a defendant's infection, then that cannot serve as a defence to invalidate the victim's consent. And lastly, we have Tamaki, 1984. In this case, it was held that consent can be withdrawn at any time during the act. So if consent exists at the beginning, it will not automatically subsist until the end. It can be withdrawn at any point in between. And lastly, part 3, we look at whether the person consenting has the capacity, both physical and mental, to give consent. Mental refers here to the person's state of mind, whether they are drunk or have any other condition that impairs their ability to understand what is going on. And physical refers to being of the age to give consent as according to that jurisdiction. So we have 3 cases here that we can look at. First of all, R.V. Bree, 2007. In this case, it was held that if you are suffering from a temporary loss of control, be it by drink or drugs, then you cannot give consent. But the mere existence of alcohol will not invalidate consent. You have to look at it on a case-by-case basis. Of course, people can handle their alcohol in different amounts, so that's why we have that sort of provision. Next, we have RVK 2001. This case is to do with age. In this case, the defendant believed the victim to be over the age of 16. The victim was not, and the defendant was convicted of indecent assault. It was held that the prosecution must prove in these types of cases that the defendant had an absence of a genuine belief as to the victim's age. The prosecution will take into account the reasonableness of a belief, and the more unreasonable it is, the less likely the belief in it was genuine. So the more absurd, more far-fetched, more ludicrous it seems, the less likely that the defendant had a genuine belief and would be convicted of indecent assault. What's also notable from this case is that this defense of mistaken belief as to age only applies where the victim is 14 or 15, of course, within UK law. If the victim was 13 or below, this defense will not apply. You cannot get away with saying that you were mistaken as to their age. So that's quite an important thing to remember. And lastly, we have Sutherland versus UK, 1997. In this case, 2 homosexual men were convicted of assault because they had sex below the age of 21. At the time, the age of consent for homosexual couples was 21. They took it all the way up to the European Court of Human Rights, and they managed to successfully challenge that provision, and the age of consent was equalised, as with heterosexual couples, to 16 years old. So that covers the test for valid consent. We've looked at whether the person is free to give consent. We've looked at some different contexts in which they can be informed as to what they're consenting to, and we've just looked briefly now at the age and mental capacity of a person to give consent. And now we're going to move on to looking at consent in different contexts and as a defense to different types of harm. So before we get into the last part of this video, I just need to briefly mention one important thing about consent. Remember that consent is a defense to harm in certain contexts and situations. For example, if you get a tattoo, a piercing, or even have a medical operation, consent has to be given in all those cases, otherwise there will be a crime committed, usually of assault. If you look at a sexual context and sexual activity, consent is needed from both parties, otherwise there again will be criminal charges. So this last part of the video, I want to look at how powerful is your consent in terms of the harm you're able to consent to. How much harm does the law allow you to consent to before it says, no, that's too much and that's too dangerous? And we're going to look at this in the case of 4 different contexts. Firstly, in sports. Secondly, in rough and undisciplined horseplay, which is kind of like fighting. Thirdly, in sexual activity. And lastly, in marriage. So let's look into these in a bit more detail. So looking firstly at sports, we have 2 cases. The first case is Rvdiker from 1888. In this case, it was decided that illegal prize fighting contestants will be guilty of assault regardless of consent. Effectively, what we're saying here is that if you meet up and agree to fight with someone for a prize, then that will be assault irrespective of whether both parties have consented or not. Now, you might be wondering, if illegal prize fighting is held to be unlawful, what about boxing, UFC and MMA? Well, those activities are regulated, controlled and involve licensed participants. So that's why the law gives an allowance for those sort of sports. The other case we have here is R.V. Barnes from 2004. In this case, a footballer had been tackled and suffered injuries amounting to a Section 20 grievous bodily harm charge, and the defendant was convicted. The convictions were upheld, and it was stated in this case, quite important point here, that consent to participate in sports amounts to consent to what is reasonable to expect in that sport. So you cannot consent to what is above and beyond the harm you expect to suffer in that sport. As an example, if you are a footballer, you wouldn't expect to be punched or have a brawl or be subject to any of those sorts of injuries. If you're a boxer, you wouldn't expect to be kicked. But maybe if you're a footballer, what is reasonable for you to expect is perhaps a muscle strain, and a bone injury, a fracture, and those sorts of things. So in the context of sports, you have to look at what is reasonable for a participant to expect to suffer in that sport. For the second part here, we have rough and undisciplined horseplay. This basically refers to little fights and scuffles you might see in playgrounds and that sort of thing. We have two cases here. The first is R.V. Jones, 1986. In this case, two boys were convicted of grievous bodily harm for the injuries they caused to another boy. But it was said by the judge in this case that boys will always engage in rough and undisciplined horseplay and will continue to do so. It's kind of saying the sort of boys will be boys type thing, take of that what you will. And basically, the law gives an allowance for those types of activities because they're not dangerous to the wider society. It doesn't affect that many people, and it's not maybe considered as harmful as some other situations. For the third part here, we're going to look at sexual activity. We have one case. This is quite an important case, R.V. Brown, 1993. In this case, two homosexual men, both consenting to sadomasochistic activities, had taped their encounter. That was then later found by the police, who brought charges, and the men were convicted. They appealed all the way up to the Court of Appeal and the House of Lords, as it was then known. Their convictions were upheld, but their sentences were initially reduced because they did not know what they were doing was criminal. The most important takeaway from this case, however, is that in the context of sadomasochistic activity, you cannot consent to that above actual bodily harm. That is the top end of what the law allows you to consent to in that context. Just going one further here, one of the judges in that case, Lord Templeman, did state that I am not prepared to invent a defense for sadomasochistic sexual behavior, and that society is bound to protect itself from a cult of violence. So quite strong wording used there, and we'll just revisit that briefly after the next two cases. For the next two cases, we have the fourth context, so in marriage. First of these cases is R.V. Wilson, 1996, where a man had branded his wife's buttocks. And if you don't know what branding is, it's basically where you have a metal rod, you heat the end of it and you stamp it into someone's skin. So it's quite painful. But the convictions for the husband were quashed because the aggressive intent was on the wife. She had consented and instigated the activity. So in these sort of situations, we're looking at who's instigating, we're looking at the intent as well on the aggressor and the victim. The other case we have here is R.V. Emmett, 1999. In this case, a couple were engaged in sexual activity involving erotic asphyxiation and lighter fuel that resulted in burns. However, in this case, in contrast to Wilson, the court said this is too much. You cannot reasonably consent to this level of harm. I think the reason we have that difference is in Wilson, branding, yes, while quite painful, is not necessarily fatal, but asphyxiation can very quickly turn bad in any situation. So I think that's why they've made that difference there. But however, we do see a slightly inconsistent approach with the law, because you look at Wilson and you think, right, you can consent to this amount of harm. Then you look at sports and think, okay, you can, depending on the sport, you can consent to certain quite high levels of harm. But then looking at R.V. Brown, they kind of draw the line a bit closer, and you start to think, why is that? Where's the consistency there? It was stated at the time, and you can see in the strong wording from Lord Templeman's writing in the judgment, there was a rumour, there was the possibility that the judges had a slight homophobic angle to it. And if that is the case, and something similar to R.V. Brown came back to the courts now, I think it would be decided differently. But I want to pose this question to you guys out there. How far do you think consent should go as a defence to harm? How much do you think a person should be able to give consent before the law cuts it off and says, no, that's too much? Or even if that should happen at all, should you be able to consent to any amount of harm? And I'll leave that to you to figure out and to discuss. So thank you for watching. This is the first episode of Know Your Law. We've covered the topic of consent, and I hope that you've learned something about the legal foundations, the grounding of consent, and some of the cases that we've used to explore and understand consent. So please leave your comments in the comment section below. I'll read them all. I can't wait to hear what you guys have to say, and please continue to keep an eye on the channel. We'll be releasing content every week, hopefully. So thank you for watching. Please leave a like and subscribe. really helps to grow the channel, and I want to be able to deliver this type of educational content to as many people as possible. Thank you for watching.